welcome. Hello. Hope you're in good health this morning, and certainly thank you for coming out to the 2014 American Indian and Indigenous Studies Seminar Speaker Series. For those of you who don't know me, my name is Gerald Richardson. I'm a Haudenosaunee and Tuscarora native from what is now Virginia, North Carolina, and kind of related territories. I want to acknowledge my own status and all of our collective status here as guests on the Cayuga traditional territories, all of which Cornell sits. So acknowledging people, Indigenous peoples and lands that we're in. I want to begin with a word of thanks as well to the Haudenosaunee and Ula Mansfield for their incomparable support and guidance for the seminar, putting the seminar together this semester. It's really been a pleasure to work with them and bringing it all together. Likewise, I want to just acknowledge the support of the director of the AIP, American Indian Program, and American Indian Studies more broadly, Jolene Rickert, for all of the work that she has and continues to do, both visible and invisible to so many of us who participate. Finally, I just want to provide a welcome for all the students who are enrolled in the seminar for credit this semester, and just kind of a housekeeping point, if we could get together, potentially introduce yourself and get together at the end of our session today, just for a few kind of comments about the overall structure of the seminar and expectations and so on. It would be really nice to do that. The seminar is a really long-standing tradition in the AIP and provides faculty and graduate students an opportunity to interact and converse with leading figures in American Indian and Indigenous studies. In short, it provides a way to further the project of Indigenous studies arguably with the people who are setting the terms for the debate within the field, nationally and internationally. And today we're very fortunate to have Professor Gerald Torres with us. Professor Torres is the Jane M. G. Foster Professor of Law here at Cornell Law School, where he teaches on federal Indian law, water law, and of course, environmental and social movements with Lonnie Kinnear. He's the co-author of the book The Myers Canary, Enlisting Race, Resisting Power, Translating Democracy, which is a key text, really, I think, in the conversations at the intersection of critical race theory and federal Indian law, along with many other articles, of course, and essays. He's a vast array of experience, of which I'll only highlight his time as counsel to Attorney General Janet Reno, as well as Deputy Assistant Attorney General for the Environment and Natural Resources Division of the U.S. Department of Justice. So it's with great pleasure to introduce Professor Torres and have him kind of kick off our seminar series for this year.
Thank you. I was say one of the things that we managed to do at the Department of Justice is to, largely because of Attorney General Reno, who I think, unbeknownst to most people, was really interested in, her mother had a relationship with the Miccosukee in southern Florida, and so she had an interest in Indian issues, and we created something that still exists. It's called the Office of Tribal Justice in the Department of Justice. And what the Office of Tribal Justice does is, it's a very simple idea, right? It's issues concerning tribes come into the Department of Justice in many forms. Come in as resource claims, tax claims, criminal claims, contracts claims. And my view was that if we have a policy for dealing with tribes, all of those cases ought to be managed consistently. That you shouldn't have the civil division managing Indian cases one way and the environment division managing cases a different way, that they ought to be consistent with the policy that the administration has. And so we created the Office of Tribal Justice to coordinate the approaches. As you can imagine, that was understood not as a very simple straightforward idea. What was understood as a power grab within the Department of Justice. So it was opposed hammers and tongs by all of the other departments, and without the leadership of Attorney General Reno, it wouldn't have happened, because she basically said, cut it out. And because she was Attorney General, she could get away with it. I want to apologize in advance for two things. One is I'm still recovering from, I'll just call it the croup. I have no idea. I was in New Zealand and got back about 3 weeks ago and was stricken with some horrible affliction. And I'm now in the third week of it, and third doctor, I would say, and third round of various kinds of treatment. And so my voice normally doesn't sound like this. I feel like I'm imitating some bad actor in a gangster movie. So I apologize, but my throat's really sore, and so I sound like this. The second thing I want to apologize for is I sent you an article which, if you read, you're wondering how in the world is it possibly related to the topic that I'm supposed to address, right? Because the topic that I'm supposed to address is the relationship between the UN Declaration on Human Rights for Indigenous People and the claim to a human right for a sustainable environment, human rights to environment. And the paper I sent you is really a paper that tries to uses a current, relatively current Supreme Court case to try to map the relationship between critical race theory and Indian issues, or Native American legal claims, largely through the lens of the obsession that we have in this country, at least the obsession that the law has with treating claims about cultures that are different from conventional, ordinary, garden variety, quote, American culture, right, as a racial issue, right? So Indian issues, which the Supreme Court itself has said are not racial issues, nonetheless get refracted through the lens of race because of the obsession both of the justices, but also in some ways the obsession with race in American law. And so I can talk about that one, since I did give you the essay, and I hope some of you read it. But I also want to talk, so I'm going to kind of divide this, it's actually going to be two talks. And maybe they'll end up being related. But if not, then they're not. We can talk about two separate things, right? But the other talk will be about the relation between human rights for Indigenous people and human rights to the environment. And you can think about human rights to the environment. One way to think about that is in the context of environmental justice. And I'll talk about that a little bit as well. So, given that in law, what I just did is called confession and avoidance. I just wanted to out myself because I've explained to you, what I'm going to do wrong, and I hope that it can be forgiven in advance.
I think it's called that in Catholicism as well.
Yes, exactly. So I'm going to try to do both, unless there is a distinct preference for one or the other. In which case, there's a story. I spent the last 17 years in Texas, and so you learn a lot about Texas lore. And Lyndon Johnson, who is one of the great heroes of Texas, went to Teachers College, and he tells a story about graduating from Teachers College, and it was just after the Depression, and he really needed a job, and so he went to a small town, Cayuga, Texas, and applied for a job there, and went through all the interviews and it was all a great success until he gets to the last interview. And then he's got to stand in front of the Board of Education there, and they ask him the question, you know, what are your views on evolution? So this is he realizes a question that is susceptible of, you know, not clear what answer he should give, right? And what he says is, you know, I needed the job so bad that I just looked him in the eye and said, you know, I can teach it round or flat. And so that's basically what we're going to do. And so what I'm going to do then is I'm going to start with the human rights argument, and then I'm going to segue into the way in which that would be misunderstood in American law, largely because of the obsession with race that we have in American law, and we'll see whether it works, right? And if it doesn't work, at minimum, you will have gotten a lunch, and so we'll see. Okay. For a couple of decades now, right? There's been a movement, an international movement, around the world, both within the Western Hemisphere in the Inter-American Commission, but also at the UN, and within the domestic politics as well, to have a declaration of human rights for Indigenous people to be declared and for it to be specified. Within the United States, it's largely, and within many countries, it's largely been opposed because it's founded on the question of whether it is a human right that applies to individuals or a human right that applies to groups. The United States has largely opposed it because, and I remember having a 3-hour discussion, we'll call it, over whether it should be a human right for the self-determination of people, or a right to the self-determination of peoples. And so the entire argument was about whether there was going to be an S at the end of people, right? The State Department was vigorously opposing peoples. The Justice Department, largely because of Justice Reno, Attorney General Reno rather, I wish Justice Reno, said, no, it's got to be peoples. And so we had an aisle with the Justice Department we lost. But the argument was, the State Department was, that if we say that there's a right to self-determination for peoples, it will never get adopted because most of the countries, they're not really worried about indigenous people. What they're worried about are the subnationalities within the countries that make up Europe. And so, as we saw with Yugoslavia, as we're seeing with in Iraq now, right, is that there are subnationalities that would be a threat to the system of nation states, which the United States depends on. Right? And my argument was, well, that's something that can be argued and discussed within the context of the nation states, but that within the nation states there are indigenous people who don't even have recognized claims to nationhood, and that they can develop these claims to nationhood within the context of the existing structure of nation states, and then that ought to be the debate that we have going forward. And in some ways, that is the debate in the Western Hemisphere. The question of whether the people in the Western Hemisphere, the indigenous people in the Western Hemisphere, have a right to a kind of national existence within the context of nation states as they exist. As a footnote, one of the things that's important to recognize that often gets overlooked, I think, when people are talking about this, is that it all stems back or relates back to the colonial project that the British had as against the colonial project that the French had or the Spanish or Portuguese had. Because the colonial projects, as they built them out, created a different juridical existence for Native people in the territories that were colonized by the British or those that were colonized by the Spanish, Portuguese, or French. And I'll just talk briefly about that. Right? In the Spanish and the Portuguese essentially didn't recognize any pre-political existence of the indigenous people they confronted. When they arrived, right, they read the essentially sovereignty proclamation that the crown required them to read. They were, the indigenous people they confronted were given the choice to convert, and if they failed to accept that choice, then they were subject to being killed. Pretty simple. In the original colonial project of the French, as they came into Canada, was largely commercial. So some of the earliest relations between the French and the indigenous people they encountered were commercial agreements. And so when you trace back and look at the documents, what you find are essentially treaties, but they're really commercial treaties in the way that we understand now. And so they were the French were allowed to come into territories, and they were allowed to make trades. Now, that doesn't summarize the entire relationship of the French and the New World to indigenous people. The British, on the other hand, had a policy of exclusion, by and large. That is, they were creating a new, in their view, a new nation, and the indigenous people they confronted here were not to be conceived of as part of that polity. What they did do, though, is they recognized a pre-political existence of the nations that they encountered, so that the way they dealt with the indigenous people that they confronted was, put aside warfare for a minute, right? Was, before I say another sentence, it's important to remember that for all of the European colonists, they had this idea that whatever they did, it had to be legal, right? That is, there had to be a legal framework that rationalized and legitimized whatever they were doing. So the Spanish legitimized it by reading the proclamation before they killed the natives. The British excluded the native people they encountered from the polity that they were creating, but entered into arrangements, largely peace treaties, right? Because one thing when I teach federal Indian law that I require students to remember, right, is until 1871, Indians were a formidable military force in North America. And so the treaties were largely peace treaties. Right? They were treaties to end hostility, and to end hostility by defining borders and then creating jurisdictional boundaries. So the British approach, the British colonial project, was to basically exclude Native people, but it had the effect of recognizing pre-political existence for Native people. That's really important. I think that's really important because when we get to the question of the status of Native people, one of the things that the treaties recognized, whether they were honored or not, right? The idea that there was a political community that you could negotiate with was an important idea, but it also forms the basis for asserting continued national existence for the tribes that are found, and the confederations, not just tribes, right, but for the confederations that you find in North America. So, when you start talking then about human rights, human right Declaration of Human Rights for Indigenous People, one of the things that's important to recognize is what does that mean? And what I want to focus on today, because it's true both in the UN Declaration but also in the Inter-American Commission and the Organization of American States, right? One of the critical elements is, and this is actually important for non-Indian groups as well, right? Is it recognized a collective right to culture, right? To maintain culture, right? So that all collective rights in the international context, in the UN context, all collective rights, in my view, are really parasitic on the notion of collective rights that arise from the system that was used to develop relations with indigenous people, right? So that in fact, what we're going to get to the right to environment, right, in a minute, right? But the idea of a collective right really is founded when you're talking about native people and not talking about nation states, right? We're talking about subnational groups, on the relationship of these subnational groups to a continued political existence in relationship to nations, but also in relation to international bodies. But one of the critical things that the UN Declaration provides is for a right to culture. Now that's important, right? Because you have to then pull apart what a right to culture is, right? I'm only going to pull it apart to this extent. And what I'm saying is, it's like, I only think in really small ideas, little ideas, right? So that the idea of a right to culture necessarily implies a right to the material conditions that allow you to maintain that culture. That culture doesn't exist in your brain, right? It doesn't exist in the ether, right? It exists, there's a material content to culture. And without the material conditions to reproduce that culture, the idea of a right to culture is essentially a meaningless idea. So, once you concede that there's a right to culture, right, then the question is, what does a right to culture entail? There are two things. One is there's the political dimension, that is, to what extent can this right to culture be used as against national states, right? Or to the other extent is, what can this right to culture how can this right to culture be used to maintain the material conditions to reproduce culture? Okay. In the context of American law, right, the pre-political existence of tribes recognizes it's essentially a jurisdictional claim, right? And recognizes a jurisdictional claim. It's been carved back in many ways, but it really doesn't address this question of a right to culture because it's presumed to be part of the national existence or the cultural existence of the tribes as they exist. But what it does do is it creates a relationship between the national government and the tribes over the maintenance of resources that the tribes have at their disposal. One of the things, when you look at federal Indian law, one of the things that the law makes clear and distinguishes is what was critical to the tribes for the cultural history of those tribes, right? So that if you're, for instance, if you're a tribe that is a marine tribe or a tribe that is tied to fisheries, then the claims you have over those fisheries, right, are different than tribes that were non-fishing tribes, for example, right? So that the material conditions for the survival of the tribe are tied to the cultural conditions that define that tribe. My argument is that that's true in the international context as well. It is the idea that there's a material foundation for the for the maintenance of culture, right, is critical to the idea that there's a material conditions for the maintenance of the environment. That is, if in fact, and that's why I think this idea that, and here, I mean, I want to quote someone, this is Richard Hiskes, I believe his name is, he's a philosopher in Connecticut. Right, he said, for the past 50 years or so, especially in Western societies that profess an individualist ontology of human rights, group rights have come to refer to claims, to rights claimed by indigenous groups within individualist societies who view themselves or are somehow viewed as different. Right? So one of the ways in which the idea that you can take essentially an individualist, which we are, an individualist culture, and claim a group right, and this is why the rights of indigenous people are so critical, is to somehow say that their rights are different than the rights that the majority, that is non-indigenous people, claim. That is, their rights that are tied to their membership in this culture. Well, if that's true, right, and in fact that's one of the ways in which the rights of indigenous people have evolved, and those rights are tied to the cultural maintenance of those groups, then the material content of those rights are tied necessarily to the cultural definition of those groups. So how do you get from that to a right that any of us may claim to an environment, the right to the environment? Well, you can do it through two ways, right? Right. One, you can claim that, one of the arguments you would have to claim, it seems to me, is that the maintenance of certain environmental conditions are necessary for the maintenance of the culture that we are part of. That's one. You can also do it in a different way. And you can do it a different way by saying that the very legitimacy of government itself is predicated on the claims that people make or people have to resources that permit their reproduction. Okay. So where do I get that idea? Right? That idea is actually a Roman law idea. Right? And it comes from Roman law, and gets, my argument is it gets refracted through this kind of group rights claims that indigenous people make. But it's a claim that there are certain resources that are so necessary for the maintenance of a culture, of a society, that they're incapable of individual ownership. Okay. Now, we can think of one right now, right, presumably. What's that?
Water.
Water, for one, although water is capable of individual ownership, right?
Wow.
Some kinds of water.
They push back against that in Bolivia.
Right, they push back against that in Bolivia, right? No, and I'm going to talk about water, because water is actually where it arose. But what are we all doing now? We're all breathing, exactly. We're all breathing, right? So the argument is that everyone who breathes, right, has some interest in the atmosphere, right? In the quality of the air we breathe, right? And that attempts to subdivide, one of the geniuses, and I use that in scare quotes, right? One of the geniuses of Anglo-American jurisprudence, right, is our capacity to divide property in at least 5 ways, right? So you can divide, you can do anything that you can think of as a property right, like that cup I can think of as being mine, right? But if it's mine, right, I can divide it in a number of ways to this group, right? I can divide it temporally, so I'll give it to you till 10 till, or till noon, right? So you can have it for 10 minutes, right? After that, I get it back, or I will then lease it to you now, right? So I can do it, temporally that way, right? I can also say that, look, what I'm going to transfer to you is the legal ownership of this cup, but I'm going to reserve to myself the equitable ownership of this cup. And so that means I transfer you the cup, but I get to preserve the use for myself, so that even though you own the cup, I get to use the cup to drink water out of, right? I can also do it across generations, right? So once you start to think about being able to do this across generations, but also recognize that there's a resource that we all have in common, then you have to ask, it's not, the resource we all have in common is not just for us, the living today, right? But for this other group who we're going to call, the people who follow us, or we can call them whatever we want to call them, right? Our descendants, right? We can call them the people to whom we owe a duty, right? So just as we owe a duty to indigenous people to maintain the resource, to not interfere with the resources necessary for indigenous people to reproduce their own cultures, we have a duty to each other and a duty to the people who follow us not to use the resources in a way that ultimately prohibits the development or the maintenance of the culture within which we find ourselves. So let me talk about air for a minute. Right? I've suggested that all of us have an interest in the air, right? The quality, right? If you breathe, you have an interest in the air, right? Well, there is, of course, a foot in American law, environmental law, the idea that polluters can trade the pollution loading capacity of the atmosphere, right, and get value to that, right? Or people can trade the carbon loading capacity, right? That's the Kyoto or Rio, right? We can look at those. Well, I'm making a very simple argument. My argument is it's not theirs to trade, right? Or if this trading scheme is going to be permitted, then there has to be a way for those of us who have an interest in that resource to capture the value of that resource, right? And I don't mean capture it for the states of which we are a part, right? I mean to actually capture it for ourselves, right? That is, if there's value to be made from a trade, then each of us get a share of that value. It doesn't go to the Treasury Department, it goes to us. That's the claim. Because it's ours, right? We didn't give to the state, right, the right to breathe. And the state doesn't, bestow on us the right to breathe, presumably. Presumably, once we're alive, this is a right that obtains naturally. So that the idea is that there are certain things that are inalienable, that are necessary, right? So this is a broad version of the claim. For water, it arises in the context of, for instance, the right to have access to the shore, the right to navigate on waters, right? And the right to navigate on water is a right that's inalienable, right? At least arguably, right? And something that belongs to us in a pre-nation state, pre-legal condition, right? And the very thing that gives legitimacy to the state is the protection of those things that we have an interest in, that we're trading membership in the state, right, for protection of those resources that we have an interest in. When tribes trade through treaties or other mechanisms, trade with the federal government, right? The right to defend with arms, right? Those things which they claim, what are they getting in return? Right? They're getting in return, it seems to me, not just the things that the treaty represents, but all of those other resources that are necessary for the tribe to maintain its self-defined existence. That is, who they are, recognizing, right? And this is, because most people in the United States, unfortunately, have this idea that tribes are somehow frozen in amber, right? And tribes are not allowed to evolve the way, say, American culture generally is allowed to evolve, right? Right? So that the duty that's owed to tribes as groups also evolves. Okay? Also evolves. But it is an inalienable claim that in fact underlies the legitimacy of the agreement that's made between tribal groups and non-tribal groups, certainly in the Anglo-American context. My argument would be that it also exists for indigenous people generally, even where the original colonial project didn't recognize that distinction. That so long as indigenous people maintain a political existence and a cultural existence, that, take Mexico for example. Right? In Mexico, there are 98, last time I looked, 98 languages that continue to be spoken in Mexico. You go to a place like Puebla, and over half the people who live in Puebla speak Spanish as a second language. Right? So they speak their indigenous languages as their primary language. Right? So these cultural groupings still exist. One of the questions I want to pose is, what's the political meaning of that continued cultural existence? And my argument is that if there are human rights for indigenous people, and part of the human rights is the maintenance of the culture, then one of the things that has to recognize is a political expression of that cultural existence. Even if it means that they've got to come to terms with the national grouping, right? Because this is the big fear, right? The big fear is that they'll destabilize nation states. Another footnote: nation states are already destabilized,
Yeah.
right? If you read, I don't know how many of you are familiar with the book *The Shield of Achilles*, right? But if you read the work in international law already, it makes two arguments, right? One argument is kind of interesting, which is that Al Qaeda is largely going to be studied in business schools as opposed to international relations courses, right? Because of the way they've organized, right? But the second is that the thing that legitimized states in the past is the Westphalian state is basically over, and that the only obligation states will have to the people is to maintain markets, and that if markets exist, then the state has fulfilled its duty to its citizens, right? And whether citizens have, as long as there are no artificial barriers to participation in the market, then the state is legitimate. That argument's afoot currently, right? And has some legitimacy. And so so the question of whether the state is in flux at all, right, is another question. But my point is, that was just a footnote. My point is that regardless of the insecurity of the nation state, there is this continued existence of pre-political existence of indigenous people who have a basis founded in culture, put aside morality, right, to claims that over resources the state would otherwise have a monopoly over, or which it could control the ownership of. Those people who are claiming a right to the environment essentially are using that same logical structure to make a claim for the environment. That is, there are certain environmental qualities that have to be maintained necessary to permit the culture to continue to evolve, and they can't be traded away through market mechanisms that essentially prohibit the culture from being sustained. So that's that argument. Okay. Now we can stop there for a few minutes and talk about that, or I can segue into the second piece.
Perhaps we can ask if any students have questions or comments. That's great.
Not just students, I mean,
And then-
students
and then-
first.
but, yeah, and then faculty. Also.
When you're talking about these rights and cultural rights, it seems like a lot of them in the U.S. are defined for subsistence use. So we've gone through like 200 years to gain subsistence rights, and you're kind of suggesting otherwise. I think in some of the comments you're saying that we have a right to evolve like the rest of American culture, as you said, and so but as it stands now, the rights that we have in the U.S. are more subsistence oriented. And when we talk about culture, culture is understood as like a subsistence existence. So how do you talk about efforts of modern tribes, in larger efforts to do economic development? Like if you want water rights beyond desert agriculture, and you want to create an IBM plant or something like that, that's something that you have a hard time arguing.
Well, when I was in the Justice Department, one of the claims that I made, one of the things that I confronted consistently was this idea that tribes only had those rights that were defined at the point of their cultural existence, the time they entered into the treaty, right? And my view was that's absurd, right? Now, one of the claims I was making, which my environmentalist friends resisted, was whether tribes in northern Minnesota could use snowmobiles to go out on the ice in the winter. And my environmentalist friends said, "Oh, that's a horrible thing. We can't." And I said, "What? They can't use gasoline engines, right? Because they didn't have gasoline engines when they signed the treaty. So that's absurd. It's absurd, right? That if they have a right to use the resource, they have a right to use the resource that is consistent with whatever their capacities are, right? And we're not going to require them to dress in feathers and wear buckskin, in the dead of winter, right? To go hike across the frozen lakes in the boundary waters, right? They can use Gore-Tex too, right? This is not like this is, that they don't exist for us, right? They exist for themselves, right? And that recognizing that they exist for themselves is in fact part of the treaty agreement. That's the argument I was making, right? So that water is a different issue, right? Because they're in this sense that not in use but in quantity. Because there are different tests that are assigned to determine what the reserved water right entailed. Right. Now the problem is under federal statutes, what is it?
Is it like PIA?
Yes, the PIA. Practically irrigable acreage,
yeah.
Right? Is used, right? Well, even that is actually a problematic construction, right? But there are ways of using water, right, that in fact are non-consumptive, right? And so to the extent that they are non-consumptive and thus don't have a negative impact on other water users, because here we're largely talking about the West, right? Right, and the West is where all water issues are going to be really, really, really contested because there's just not enough water, right, in the West. I mean, my home state of California, right, its main reservoirs is the snowpack, right, and the average snowpack is 28 feet, right, and for the last 5 years they've had less than 1/4 of the average snowpack in the Sierras, right, so it's as though you drained all the reservoirs that you draw water from by 3/4, right? And then you've got a portion of water. So the water issues are going to be really intensely fought out. But in terms of what the economic development is available to tribes, my view is, and you know, and I think it's only those people who, and here we can segue into the race paper, right, who have a kind of racialized vision of Indians, right, who would argue that tribes aren't permitted to use the resources in the way that they decide. You know, Canada doesn't get to decide how the United States uses its resources, except to the extent that there's a conflict between Canada and the United States, right? Well, why is that? Sovereignty, right? Exactly, right? It's like because you're sovereign, right? And if the tribes are sovereign, right, then you know, people who aren't, you know, part of the tribe don't get to tell the tribes how they use the resources. I mean, this is a really simple idea. It's not a complicated idea.
The problem is, of course, you know, the whole Declaration of Indigenous Rights is framed by the nation-state structure.
I recognize that.
Yeah, and so even though nation-states are destabilized, they're still pushing back against that destabilization in obvious ways.
Absolutely.
The Ukraine-Russian business is one example.
Right.
One example of that. So,
one of the questions, of course, is whether Ukraine was ever really a nation, right?
So, in any event, so
I mean, the Russians don't think it was, right?
So you have this problematic, the ground of federal Indian law, domestic dependent nations, and the domestic dependent, oxymoronic as it is, as when it goes with nations, because nations are supposed to be foreign and independent. Nevertheless, presents this, this is the pushback of the United States, basically colonial body of law, which says we're going to control this, you're subordinate. So ultimately, the resource control, even though you own what's under the earth, right, you got to filter it through the Interior Department and the legal systems there, and we'll negotiate with the corporations, right? We both worked on the Navajo land dispute, so I mean, that's a prime example of that issue. The other thing I wondered about,
I have a couple of points to that.
just one more thing, and then because the Declaration, you know, there's a big conference right in New York about implementation of the Declaration, which is kind of the sticking point. Is how do you know where's the teeth in international law that's going to come to these nations and make them fulfill all of these articles that are in the Declaration. But the other thing that's interesting here is rights. You're talking about rights to nature, and I certainly follow your argument and agree with it. But there's also the Ecuadorian Constitution and the Bolivian Constitution, where nature has its own set of rights, which might actually present some problems to the right to nature of indigenous peoples. I mean, one could see certain kinds of extractive issues coming into conflict with those constitutional principles, which are pretty ideal at this point, but nevertheless are being thought. So.
Now, two things, and I'll respond to the second first. One is actually one of the great things that I have this year is I have an Ecuadorian graduate student that I'm working with who's writing about the new Ecuadorian Constitution and the rights to the indigenous rights in the context of the right, the nature having its own rights. Years and years and years ago, I worked with Kunai in Ecuador to once they discovered oil in the eastern province, right, which was of course already a reserve, and so at least as a legal matter, right, they weren't permitted supposedly to grant concessions to extract the oil from the eastern reserve, right, and this is why one of the things we tried to negotiate was, because the Indians knew, I mean the tribes that were there, and the Confederation, right, knew that given the price of oil, the need for oil of the state, that they weren't going to keep that the oil was going to be extracted. And they weren't kidding themselves about that, right? The question was, okay, since the oil is going to be extracted, what can we do to minimize the impact on us for to that extraction. One of the key issues was whether they would build permanent bridges. Right? And so there was opposition to building any permanent bridges, because the idea was if you build a permanent bridge, the non-Indians are just going to follow the roads into the province and they're going to settle, and we've lost, territory. If you build non-permanent bridges, you can extract the oil, assuming you can clean up, which they didn't, of course, and then you could leave, right? And that fell apart. That negotiation fell apart. But it largely fell apart because of the environmentalists. Environmentalists essentially found themselves opposed to indigenous people, and wanted, were arguing that there should be no exploration, right? And so the capacity to extract concessions from the government founded on this, basically a binary decisional process, and my friends down there used to call the environmentalists the infrareds, because they're red, but you just can't see them, right? And so the environmentalists, in fact, became the enemies of indigenous people.
Yeah, that happens a lot.
Yeah, it happens.
Right.
Yeah, whale fishery.
Right, exactly. Knock on,
Right.
exactly. So there's that. Now I recognize that, and there's footnote 5 in the Venati opinion, which is really interesting. I should have actually brought it. It's what's interesting about it is when you look at all the case books for the Indian law, footnote 5 is always excised. It's never in the case books, right? And so I always then have to put it back in, and and why do I put footnote 5 back in, right? None of you know what footnote 5 is. I'll tell you what it is, right? Footnote 5 is it speaks to the claim that the tribal advocates were making, which is that dependence, and if you read the law, it's true. It's just right. Dependence is a political designation. That is, in the same way that the principalities of Europe are dependent upon their large neighbors, right? They don't have less sovereignty, right? But they also recognize that if Germany wants to invade, it could be a small country near Germany, they can, right? And so there's this relationship of political dependence, right? But that relationship of political dependence has boundaries and contours, and the argument that they were making in Venati is that that political relationship creates obligations on the federal government to act in particular ways. What footnote 5 says was, no, dependence means that the Indians rely on us for blankets and rations, and right. And so, what you get when you read all of the cases, right? What you start to see is the decay of this idea of dependence as a political notion that created reciprocal duties to one where the tribes are, in fact, empirically dependent for their survival on the largesse of the federal government, right? And so one of the tasks that I've undertaken for myself, which is largely all of my Indian law colleagues say I'm an idiot and that it's fruitless. My view is I don't care, right? What they say is that if there's a trust obligation and a plenary, the trust obligation is the flip side of the plenary power, right? That and I hate to take this little excursion into kind of American law, right? But when you look at the early American Indian law cases, one of the things that's really critical to understand is that the legal imagination at the time those opinions were written was not far removed from the legal imagination that governed feudalism So when it talks about pupillage or ward-guardian relationship, what it's talking about is those concepts within the context of the feudal imagination that was governing the court. So that wardship and guardianship was really discussing a relationship between the crown and those people who held of the crown, and they were political obligations, right? But it also then presumed that there would be a time at which the ward would reach maturity. Between the time of the relationship being established and the ward reaching maturity, of course, all important political decisions like marriage, which was just a political judgment, right, could be determined by the guardian. That is the kind of dependency that was referred to in those early decisions. The decay of that political concept into this idea of empirical material dependency, I think, is one of the real tragedies. What I've been doing is I've now, and I'd be happy to share this with anybody, I've now read every single trust decision ever decided by the Supreme Court. I now have a spreadsheet that breaks them all down.
A little OCD there.
A little OCD, a little OCD. But because what I wanted, my argument is that there's also been a decay of this idea of trust, right? Because the trust duty is, as I just described it. The way that has been decayed is to treat it as though it's just an ordinary trust, like a trust relationship that's created when you write up your will, right? So my argument's actually twofold. One is I want to put value back into this idea of the political notion of dependence and what that means. But I also want to say, okay, let's say I lose that argument. And let's say it is just a trust, an ordinary trust. Well, then let's analyze it according to ordinary trust doctrine. And under ordinary trust doctrine, the one thing that's absolutely true, right, is the trustee is governed by the trust document that created it and cannot make decisions contrary to that trust document, but has to make those decisions consistent with the best interest of the beneficiary. Okay, you ask yourself, what's the trust document that governs the federal government? And my argument is, now we get back to the beginning of this lecture, international law, right? So that you then have to focus on international law as the boundaries for what the United States is able to do in relationship to the tribes. And what I ultimately want to get to is to formulate a legal argument that ultimately can be brought forward, whether in international forum, a FATO, right, or in national fora, right, somewhat not so FATO, right, but that will actually say, no, if there's a trust duty, these aren't gratuities. The federal government isn't doing this out of the goodness of its heart. The federal government is doing this because it reached an agreement with these people that was based on a political relationship at the time of the creation of the nation. And that, we want to talk about originalism and our founding, which is to go down that path. You want to talk about originalism? Okay, I'll talk about originalism. We want to go down that path? I can walk down that path with you. But you better be prepared to come with me, right? And it better not be a faint-hearted originalism. You're going to be an originalist? We're going to say what this really meant. Of course, they'll disagree with me. They'll say, oh, it doesn't mean that. But in fact, I want to make the argument, at least as a scholar, that it does. And I want to put that argument out there, right? And what I want to do is I want to say that all of these cases that have limited the trust duty to this kind of faint private trust analogy are wrong. Now, all of my friends in Indian law say you'll never convince the court of that. And my view is, my short-term goal is not to convince the court. My goal is ultimately to change the law, right? And if it takes 50 years to do this, if I have to convince, every Indian law student that I teach in, my 40 years of teaching that I'm going to teach, if I have to teach advocates to make this argument, if I have to argue with NARF to make this argument, which I've done, I'm going to do that, right? Because what I want to do is I want to get this, at minimum, I want to get this idea in play, right? Whether it actually succeeds in the short term, I don't have any, I'm not delusional, right? I don't think it's going to win, right? But I want to get it in play, right? And if I can get it in play, then at minimum we can get people discussing it, right? So that's why I tie it back to international law, right? Recognizing that this government has as much respect for international law as it does for treaties with Indians, right? Which is not much,
No.
right? Nonetheless, right? You've got to keep making those arguments, right? Right? When I wrote a piece many years ago called "Who Owns the Sky," right? In which I made this very simple argument that all of us own it. Well, now that's now the basis of federal litigation around the country. Right? We've actually prevailed in several states, arguing that there's a public trust duty to for states to do something about global warming if the federal government doesn't act, because the states have a public trust duty to maintain the quality of the atmosphere for their people. So it's like if you're playing a long game, right? You gotta you gotta be willing to you gotta be willing to be called an idiot, periodically, right? I have a well enough developed ego structure that doesn't really bother me, right? Because my view is, look, the only arguments I make are arguments that I can find a legal foundation for and a logical structure that supports them. I'm not, these aren't pie in the sky arguments, but there is a legal and logical structure. The fact that they're not currently the law, I don't really care, right? My view is, let's make them the law, right? Let's get the framework out there. Let's get people arguing about this. Let's get lawyers making these claims in briefs. Let's get judges used to hearing these arguments, so that ultimately, when they hear these claims, the transformation doesn't seem like an abrupt transformation, but in fact something that is more in the nature of accretion than avulsion, right? Right. So that's the idea. Okay, so that's that idea. Yeah.
So.
Now I recognize it. This sounds both. But before I get to it, I recognize that it sounds both a little bit nuts, but also self-important, and I apologize for that.
Thanks. No, I'm. This maybe comes at it from a somewhat different perspective, but it seems to me that another sort of problem, or at least issue you'd have to deal with if you're going to make a kind of collective rights argument like this, especially one that's rooted in sort of a right to culture, is not just the temporal problem of cultures changing, right, which we've already talked about, but also the sort of, I don't know, it's not quite spatial, but the idea that cultures are sort of homogeneous and agreed upon, a set of shared values, which I'm an anthropologist, so we don't talk about culture in that way anymore, and they're very heterogeneous and lots of disagreement. And so if you're going to have, and this is something that philosophers of collective rights have not, I think, adequately dealt with, is the fact that these things are always subdividable.
Right.
So if you're going to have a right to, in other words, there's always, since any culture that you're going to define is going to be homogeneous, there's going to be disagreement about what values are important to the culture. There's going to be, as soon as you provide rights and acknowledge interests to this culture, there's going to be groups within that feel as though they're being oppressed.
Absolutely.
You have to subdivide again and again.
Well, I don't know if you have to subdivide again. The question, this
but
goes to Eric's.
It doesn't really solve the problem. It just makes it more local.
But this goes to Eric's point, which is if you're dealing with nations, come on, Torres. If you're dealing with nations, right, it breaks apart, right. And my view is, I'm willing to. I recognize your point, absolutely true, and in fact confront it in the work I've done, right? But my view is, I'm gonna let the tribes define for themselves.
But
And they can find, like the Dan case, right? The Dan case, which is exactly the one, you know the Dan case?
yeah, a bit.
Right. The Dan case was critical, right? Because they got this payment from the federal government, right? And the Dan sisters said, one of their claims was, well, not so fast, right? The tribe is accepting payment, but payment to the tribe isn't payment to us, right? And the fact that we hold our property different from the tribe, the way the tribe claims we hold our property, right? And so if you're defending the Dan sisters, what you've got to say, you've got to defend the Dan sisters as against not just the federal government, but also against the tribe.
Sure.
My view is, look, or take Navajo Hopi, right? Right there, you have the breakdown between the
Tribal councils.
tribal
and the
councils,
grassroots
right?
people.
Absolutely. And my view is, do I look behind that or not? And my view is, I'm not going to look behind that. Right? That is the tribe gets to say who it is. It gets to define its own politics. I'm not going to say, well, that's not the legitimate government. I'm going to turn to, it's like, my view is, look, if they say that's the legitimate government, if they don't think it is, they get to fight it out and figure it out. But I don't get to say, I don't think you're legitimate. You're legitimate, right? That's not my, it's not my role, that's not my place.
This is the problem of colonialism.
Oh, it is the problem of colonialism,
Yeah, I
right?
mean, of an ongoing colonialism that federal Indian law basically.
I mean,
basically
the other aspect of that is that assuming that the tribes, I mean, in a sense, you're assuming the tribe is the pre-existing political entity, which in many cases it's not. And it's not even close, right? In the Yukon where I work, there was no kind of tribal structure. So the things that are now First Nations that have legal, political, territorial entities are very much a product of colonialism. They
There's no
grow
question.
out of colonial administration of the territory.
There's no question about that. That can we escape the impact of colonialism in the West or any place, right? And the answer is no, we can't, right? Right. But the other question is, where do we stand, right, in relationship to Native people? And my view is, at least the position I've taken, we can take different positions on this, I appreciate that. But my own view is, I don't get to stand in the privileged position of the colonist and say, well, this native village is really a product of colonialism, so I'm not going to act as though it's legitimate. One of the things I can do is I can work with the people there, right? As I try to do. Eric and I were both on the Navajo Hopi. You try to work with the various people and get a conversation going, but ultimately, my view is, I don't get to make those judgments, right? Okay, even as I recognize that it's the residue of colonialism. I mean, when I look at my own history, right, my personal history, right, I mean, it took me probably 40 years, right, to be able to say the word Spain without spitting, right? Because I grew up with stories of like the horrible things the Spanish did, right, to my own family, right? Then you learn a little bit. You think, God, yeah, they did these horrible things, but they were pretty audacious people too, right? Who gets in a stinking boat the size of this room and thinks I'm going to sail across the world, it's like, so you can appreciate them as humans, right, on one level, right? So, and so my own existence is a product of colonialism, right? And is it a position from which we are permitted to escape? No. And it has these particular consequences for the United States. Let's take the contiguous 48 as against Alaska or Hawaii, right? Right. First of all, you have to recognize that Indian, right, is a legal term, right? It's a legal term that has specific legal consequences. So Indian people may also be indigenous, but indigenous is a legal term, right? Also the residue of colonialism, right? So that indigenous people in Alaska and indigenous people in Hawaii are treated different from Indian people, right, as a legal term in the contiguous 48, right? And one question you have to ask is, well, why? And the answer is because the point of encounter is part of that colonial project, right? So the point of encounter with indigenous people in Alaska and indigenous people in Hawaii came at a later point at which the extension of the idea of Indianness became problematic, right? And it needs to be explored. It needs to be explored more deeply. Yeah.
This is a little bit of a segue here, but it's kind of responding to what you just said. So when you're talking about the UN Declaration of the Rights for Indigenous people, and the way Indigenous is described is kind of a popular understanding of it. You know, people who were here before a settler colonial state came into being. But in the context of I think Australia, the United States, maybe these Anglo-settler states, Canada, a lot of these, a lot of indigenous people are defined racially, right? And that's what you're talking about.
Right.
And so my question is, when you're talking about international law, why stop at indigenous declaration on rights for indigenous people, and why not talk through UN treaty on against racism and other forms of discrimination? You know, if we're talking about people being defined as a race and being treated as a racial group
Right.
here, you know, so.
Well, part of it is you can put all those pieces together. The reason I've been discussing them separately is that these are distinct legal instruments, right? And that because they're distinct legal instruments, they carry with them. You know, I'm not just talking about the logic of them, right? I'm talking about the exact character of the legal instrument. So, for instance, one of the big problems with the UN Declaration on Indigenous People is what about Africa, right? And the answer is, well, Africans aren't really indigenous people.
Also Palestine.
And Palestine, right? They're not really indigenous people. Well, on one level you say, that's lunatic, right? Right? On the other hand, you say, well, we couldn't have gotten the UN Declaration passed, right, adopted, right, if we were going to resolve that problem. Right. And so maybe this question, this is your point about colonialism, right, is exactly right. So that for instance, you take, I mean, one of the things, colonials are very clever, right? So when you look at the colonization of North America, right, the British aren't idiots, right? They colonized North America. They got chased out of North America, right? They left the people who became, the founding fathers of the United States, et cetera, right? They're all British, right? But ultimately they became that. And so then they colonized India. They colonized New Zealand. They colonized Australia, right? And what did they do? One of the first things they did is they didn't make the mistake of characterizing the territory that they were colonizing in the same way they characterized the territory they were colonized when they colonized North America. So remember what early on I said one of the critical things that's always at play is the colonists don't consider themselves brutes, right? They consider that what they're doing is legal, right? So when they colonized Australia, what they declared is that Australia is terra nullius, right? And what does terra nullius mean? It means it is a land that is occupied by no one, right? So when they landed in a land that is occupied by no one, the people that they happened to find there weren't people who had any claim to any territory whatsoever, right? This was unoccupied territory. They were on an equal footing with the indigenous people that they discovered in Australia, right? and they did it in New Zealand, right? In India, right? They said, well, this actually isn't a colonial enterprise at all, really. What it is, it's a commercial enterprise, right? And it wasn't until, you know, the East India Company couldn't maintain order that the Crown sent in their troops, right? And then imposed a colonial order in India. Well, all of this was basically learning that they, you know, that they took from the original colonization of North America, right? It's like it didn't really work here, right? And it didn't really work for a variety of reasons. But one of the reasons it didn't work was the treatment of the indigenous people they confronted, right? And so they created different legal status for dealing with the people that they confronted in these new territories, right? So you know, one of the other difficulties, of course, is this idea of success. I mean, it's all colonialism, right? The idea of successor state status, right? So you know, in the Southwest, right, you had Mexico, which originally colonized the Southwest. The indigenous people under the Mexicans were citizens, right? So that when the United States took the territory from Mexico, under successor state theory, under international law, all the Indians that they found that occupied the Southwest should have been citizens of the United States, right? Of course they weren't, right? That's the Sandoval case, right? Or take the Louisiana Territory, right? First of all, the Louisiana Purchase was unconstitutional, right? No one ever confronts that, right? But it was an unconstitutional action by Thomas Jefferson, right? But it wasn't just territory they got, right? They got a territory that was filled with people, right? And so one of the questions that, of course, people, when you talk about the Louisiana Purchase and the Lewis and Clark expedition, blah, 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 is you never talk about what was the legal status of the people who occupied that territory that suddenly came into the jurisdiction of the United States. Well, the assumption is they have the same legal status as all the rest of the indigenous people that we've come in contact with up to this point. Well, it's not at all clear that as a legal matter or even as a colonial matter that should have obtained. So that at every moment, right, you've got to both, when I said look at the colonial project, I think that's really critical because the colonial project really governs the legal status that the colonialists imposed on indigenous people that they were confronting, consistent with what they wanted to achieve in colonizing that territory, right? So what was the status of the indigenous people in Alaska under Russian law? I don't know, actually, right? But it should have governed the status of indigenous people when we purchased Alaska, right? Because we weren't purchasing it from the native Alaskans. We were purchasing it from Russia, right? So Russia was making a national claim over this territory and over the people in that territory, and that national claim carried with it a legal status for those people. When we purchased Alaska, we weren't just purchasing territory, we were purchasing all the legal claims, right, that the Russians had. And part of those legal claims would have been the status of the indigenous people who occupied that territory.
Well, hence the Alaska Native Claims Act.
Ultimately, right.
Right. I mean, so an
Right.
entirely different relationship to the
Entirely
federal
different
government.
relationship to the federal government, right. That's why when I mentioned footnote 5 in the Venati case, and I will say the Venati case was brought by one of my students. It was actually the first case she brought as a lawyer. It goes all the way to the Supreme Court, right? But those of us outside of it were terrified, right? Because the question in the Venati case was, is there Indian country in Alaska? Well, what we're worried about is, what if there's no Indian country in any place that doesn't have reservations, right? Suddenly, Oklahoma, no Indian country. Suddenly California, which has more Indians than any state in the country, no Indian country, right? The potential downside of that case was so scary that we were happy that it was actually a narrow decision, right? But the consequences were potentially profound. I mean, one of the things that, and we'll get back to the paper eventually. One of the interesting things, and when you talk about colonialism being a driving force, is, and remember I said that Indian is a legal category, right? So that if, say, the Tuscarora brought a claim and it went to the Supreme Court, it doesn't just govern the relation of the Tuscarora to the federal government, right? It's going to govern every Indian's relation to the federal government, right? So that no matter how large or how small the tribe, as the cases get decided, they're, quote, Indian law cases, right? So they apply to every Indian in the country, right? Potentially. And that's, you know, that's one of the consequences of colonialism. Now, it'd be a much more interesting and variegated legal landscape if you said, no, this only applies to the tribe that was litigating this case. Right? And there's no reason you couldn't say that, right? If it's in fact brought under a treaty or brought under a specific statute that governs that tribe, you could say this only applies to that tribe. And that would be more in keeping with a kind of international kind of jurisprudence. But it doesn't, you know, so you can have the smallest tribe. One of the reasons the Supreme Court project was initiated by NCAI and NARF was to improve the quality of litigation in the Supreme Court, precisely for that reason. Because what we wanted to make sure is that if a case gets litigated in the Supreme Court, you have the best possible advocacy. Because it's not just going to affect the tribe that's in front of the court, it's going to affect every Indian in America. Right? And so, you know, that's what I talk about the consequences of colonialism. That's one of the consequences of colonialism.
But isn't that true in general? Like if one state, I mean, if a state has a ruling against the federal government, it's going to apply to all states as well.
It depends, right? For instance, say there's a tax case, right? And you go up and you lose it in the one of the reasons the IRS and the federal government litigates this way, and the government loses a tax case in the Second Circuit, it won't appeal it, and it'll say that only applies to the Second Circuit. So only businesses in the Second Circuit are governed by this rule. All the businesses in the rest of the United States are governed by the rule that exists before this one got litigated.
That's a strategic move. If they did.
Actually, but my point is if tribes were to adopt that kind of strategic move, right? Yes, once it's ultimately decided by the Supreme Court, if it's the kind of decision that governs all similarly situated parties, that's true, right? But for instance, water issues are only going to govern states that have those particular kinds of water claims, right?
Yeah, you know, this is the disaster of the city of Sherrill case and the Latches decision.
Oh, absolutely.
That it really opened up these land cases to just a catastrophic outcomes.
Absolutely.
Why didn't someone step in to try to stop that?
We did.
Yeah, and they wouldn't pay attention.
No. I mean, part of it is you can't force someone not to take a case up, right?
But you would think that the force of the argument.
Well, you would think, right? I have to say, and one of the problems is, everyone thinks they're going to win. Right? The other thing is that a lot of times you get a lawyer, right, who says, this is the one chance I'm going to have to litigate, go to the Supreme Court.
This is a big issue.
And you want to strangle them.
Yeah.
I mean, I'm sorry, you want to persuade them not to do it, right?
I really want to hear you talk about this, and so.
Can I?
Oh, yes.
Yeah, but first, just thanks for sharing your work. And so I want to go back to, I think, Paul's initial question. If I hear your argument correctly, and it's kind of raising some issues around it. So yes, I think it's true there's like a war of gods of figures lurking behind the Taylor. Well, I mean, just some very philosophically kind of political philosophy, which is part of it, exactly. So that international arrangements, the AIIS and various other organizations you're speaking about, you're trying to describe a process where group rights, as it's been articulated already, can be leveraged into projects for environmental
Right.
sustainability.
Right.
At its like most simple.
That's the most simple,
my own
exactly.
kind of understanding. So Paul's response, and if I understood you correctly, was that, okay, given that, we've moved on in a much more complicated way to understand culture, a variety of disciplinary fields. Are you suggesting with that the individual rights is the better avenue to pursue the ultimate goal, which is how does one leverage international frameworks for sustainable environments, not simply for indigenous peoples, if I understand
Right,
you
no, it's just
correctly,
broader.
to the broader kind of set of concerns around what it means to have a sustainable environment for the future, for the generations that come, and so on. So is it fair to suggest you were articulating a position that said individual rights as a project is the better avenue through which to achieve that effort involved?
No. But what I am doing, I'm just trying to flag that because
I
often
think that's clear.
often the collective rights option is seen as something that's very, very practically difficult to make happen in reality, but that it's much superior. And I'm saying that actually it has a lot of problems. And I'm not suggesting that you should hold yourself up as the arbiter of who is and who isn't the legitimate successor or who's valid, but that in some sense, if you're going to grant collective rights to culture, and you're already making that decision, right? In whether you like it or not, you're going to grant if you give collective.
Is that the analytic move, which is to say in philosophy, I deal with what exists. What exists are a range of frameworks in play,
Right.
and that's the deal. As opposed to a speculative idealist argument that is something else. Is that fair?
Yeah, that's fair. Yeah, no. But I mean, in some ways, you know, I'm a primitive, right? Because all I'm saying is, look, this is the landscape that we inhabit.
The analytic move.
Right. This is the landscape we inhabit. And I recognize the difficulty that you point out, but within this landscape that we inhabit, this is the analytic move that we can take.
Arguably the most viable.
Most viable, right? And what I wanted to do was to take the claim that, I mean, one of the reasons we can make the claim for indigenous people is they're different, right? And they're a group already, right? They're kind of a predefined group. And
But that's precisely the point. They're
Right.
not a predefined.
well, no, they are a predefined
Only
group.
through coloniality.
Only through coloniality. I recognize that, right? And I recognize there's difficulties with that.
There's a lot of-
But there are a lot of, right, but as a legal matter, we can say this is a predefined political grouping, okay? That within that predefined political grouping, there are, we're going to recognize a right to culture, right? Okay, so that's problematic. I understand all the problems with that, absolutely, right? Actually, you know, I have, one of the first papers I wrote with an anthropologist, and I read obviously a lot of anthropology, and I'm in great sympathy with it. But what I want to say is, if there is a right to culture, put aside who gets to define what that culture is, put that to one side, is that carries with it a material reality, right? That is it can't just be a right to call yourself X, right? There has to be a right to reproduce X, right? And if there's a right to reproduce X, then that necessarily carries with it a right to the resources necessary to reproduce X, right? And so that's why we can take the claims that we're willing to make for indigenous people, as problematic as it might be, and to say that yes, there is a right that we all have, right? And this is whether it's to, you know, the people who follow us, to maintain the necessary material conditions to reproduce culture, our own culture, whatever it is, right? American culture, right? Whether we agree with the culture that we currently inhabit or not, right? We can't make the decision for people who aren't here that, and this is the global warming, right, the climate change argument, is we can't make the decision now for people who have as legitimate a claim as us to that culture and those resources.
Yeah, so maybe if I can add like an example and see how we can work with this. So say you have a tribal government, like the one where I was doing my research, Navajo Nation, and they say in order to preserve our material, in order to preserve our culture, we need to have development. In order to do that, we need to do uranium mining, let's say. And that brings in revenue, creates jobs, keeps people in the reservation instead of moving outside into the cities. Now then you have environmental groups, Navajo environmental groups, who will oppose that and also claim that the government who's doing that is illegitimate. And so they will say that traditionally we didn't do these types of things, and they'll have an alternative vision in play. So how do you deal with cultural rights in those kind of in scenarios? And these will be the real questions that you'll encounter when you do that.
One of and I understand that Pete Zahn, right, who's Pete said to me, don't try to understand chapter politics if your mother didn't speak Navajo.
Try to understand what?
Chapter politics if your mother didn't speak Navajo.
Okay.
So I said, okay, Pete, I got you. Right? It's like, so I'm not,
Right.
This is too deep for me to apprehend. And the question, this is the question of coloniality, right? The question
that's
is
basically what he's describing is always the case, I would argue. There are always very different.
Of course, but you get that argument in non-tribal contexts,
Sure.
right?
Yeah.
Right.
But then if you're saying that there's a set of cultural values that are in
and my view
regarding
is,
the environment.
and my view is, I let the Navajo decide what those cultural values are, and I,
So can you speak to like?
I mean, let me tell you an example, right? that derives right from uranium mining, right? Right. The Navajo mined uranium with picks and shovels and wheelbarrows in World War II, right? Most of the miners died of cancer, right? The federal government passed a statute that said the wives of the uranium miners would be compensated, right? And then the Interior Department refused to compensate the widows on the theory that they weren't really married because they were only married under Navajo law, right? Right. At which point I said, because I happened to be in the position at the time, I suspect anybody would have said, but they hadn't at that point. Are you fucking kidding me? Right? Right? Which was basically that was the whole nature of my legal argument. I said they're married under Navajo law, right? And you are doubly damaging these people, both by not giving them compensation and by suggesting that the children of these unions are illegitimate under, and these women, and because some of the women that I spoke to were completely, they felt like they'd been declared whores, right? Right? They'd been, had children and they weren't married, and what was the federal government telling them? And my view is, first of all, you've got to pay them compensation, and then you've got to apologize to them, right, for this, which seemed to be like, not rocket science, right? But that's exactly in reliance on what the Navajo Nation, decided for itself. And my view was that should be the determining factor for the application of federal law.
Well,
Right.
so I'm wondering, you use the language of originalism and of the federal system, right? So, given our local context,
Wait, before you, and I'm not an originalist, right?
I didn't
Right,
suggest
okay.
that.
My view was, if they want to go down that
Yes.
road, then let's go down that road, right?
That's what I'm going to get to,
Right, okay.
essentially, which is to say, let's go down the road of the kind of indigenous intellectual traditions that led to the very moment of the articulation. Right? So locally, we have Haudenosaunee people who've been engaged with the UN system at least 100 years, right? Before it was the UN.
Right.
Let's do that homework,
Right.
in a sense.
Absolutely.
But even more in contemporary terms, to the extent that figures in Aotearoa, New Zealand, Australia, representatives of tribal nation peoples help frame the very language, then it would seem to me to turn on the question of the intent
Right.
of those framers in the use of culture.
Absolutely.
And so to the extent that we would want to respect the indigenous input, as contested, as complex as it is, as a course of legal kind of argument, we would pursue the intent of the use of the term in the context of its articulation and the history of the intellectual work of indigenous people at the UN.
Right.
And so that's a definitional project that would seem to me pretty straightforward.
No, and in fact, it is, if you look at the canons of construction under federal Indian law, right, the canons of, because the canons of construction in Indian law are different from the canons of construction under ordinary statutes, right? So when there's a treaty or a statute, right, one of the things the court is supposed to look to is how did the Indians understand that treaty or that statute at the time it was passed and at the time they entered into it, right? And so that, in my view, is, okay, well, great. This is actually great, because then we can do the excavation of precisely the kind of excavation that you're describing. And that has been done to a certain extent, but it has value. And then you get to talk to the people who claim, well, we want to know what this meant at the time it was originally constructed. And you say, okay, if you want to take that seriously, we're going to take it really, really seriously.
And we're going to end up in indigenous language.
And we're going to end up in indigenous language. That's what. Are you familiar with Queequeg's Coffin? Anybody? It's a wonderful book, and it's American literature, alphabetic American literature, right? And so it goes back to writing, the literature that the people who first encountered indigenous people confronted, right? And it's a wonderful book because it suggests that the history of American literature goes way deeper than English, way deeper than alphabets, right? It goes back to the literature that indigenous people were creating historically. And the title, of course, refers to, Moby Dick, right? And the last scene in Moby Dick, right, as Ab's drowning, right? And what is he clutching, right? He's clutching Queequeg's coffin, right, which has these symbols on it that he has no understanding of, right? And it's exactly the understanding of those symbols which says, there's more here to know than you even imagine, right? And that's one of the things. I mean, the way you phrased it, I wish I had. It is recorded now. I want to come back and look at that because that's exactly right, right? And ultimately, you do end up with indigenous languages, right? Because ultimately you say, if you go back to you have to end up with indigenous languages because that's the only way you get to the meaning. And maybe you disagree with this. The only way you get to the meaning of the initial exchanges, right? You go back to there's this famous scene in the journals of Lewis and Clark, right, where the expedition, I'm blanking, I don't know whether it was the Lakota at this point or not, but their demand, they can't go any farther unless they pay a tribute, right? And so they have the sovereignty medal, right, and they have essentially the same kind of, the American version of that Spanish speech that they're supposed to give, you are now subject to the sovereignty of the United States, blah, 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 right? And so they bear them up to the teepee, it was a teepee, where the headman was going to receive them, And they bear Lewis up on a blanket, right, and treat him with respect, and they sit him down. And first of all, is it Mandan? I forget which. There's like 5 languages that the translation has to go through, right? But the critical scene is he gets in there and he presents the sovereignty medal and he reads the blah blah blah. And as he's doing this, right, what he notices behind the chief who he's talking to is a British flag and a conquistador's helmet on a post, right? And he realizes we're not the first Europeans they've encountered, right? So they're like, this is not news to them, right? And this is, it may be meaningful to us, but it's not meaningful to them, right? So that moment, it seems to me, is a critical moment in the whole journey, right? Because it's like you guys are Johnny's come lately to the party, right? And the Spanish aren't here anymore, the British aren't here anymore, we're still here, right? And now you're coming into our territory. You may be here or you may not, but you're coming in on our terms.
So that's an interesting moment. Let's thank the professor. Torres.
Oh, are we done? Oh, God, I didn't even get to my paper.
I'll read it, I haven't read it, I'll read it and I'll send you questions.
Yeah, the fundamental thing is that the American obsession with race has led to a desire to understand Indians racially, as opposed to as independent cultural political groups, right? And that's why I start with the Baby Veronica case, right? Because, and I'll just read it briefly, and then we'll end, because I know it's already gone, right? But you have the Supreme Court saying this case is about a little girl, baby girl, who is classified as an Indian because she is 1.2%, 256 Cherokee. Because baby girl was classified this way, the South Carolina Supreme Court held that certain provisions of the Federal Indian Child Welfare Act of 1978 required her to be taken at the age of 27 months from the only parent she'd ever known and handed over to her biological father. Right. And what I wanted to focus on is, or one question I ask is, right, so does anybody ever ask, how much American are you? Well, everyone would say that's an absurd question, right? Why is it absurd? Because it's actually kind of a binary question, right? You're either American or you're not American. Of course, the question of whether there's a whole literature on categories of citizenship, which I'm not going to reference here, right? But the whole question is she Cherokee or isn't she? Right? It's not how much Cherokee she is, right? It's as absurd as saying, well, I'm, 2/25 American. To say that is an irrational kind of, that doesn't make any sense, right? And my point is, the only reason it made sense in this case is because they conceive of it as a racial category, right? They conceive of it as a racial category. And if they didn't conceive of it as a racial category, the question of what percentage Cherokee she is would have been understood as absurd, right, on its face. Because the only question is, do the Cherokee consider her Cherokee, right? The Cherokee may have a blood quantum test or not, but you know what? That's irrelevant to the federal courts. The only thing that should be relevant to the federal courts is, do the Cherokee consider this girl Cherokee? If they consider her Cherokee, then the question's over, right? And so then I go through the whole issue. We can talk about it. Thank you all for paying attention. I apologize for not having as much juice as I normally have because I'm sick, and I apologize for the rather unformed nature of this discourse. But if you got something out of it, then I'm grateful. And we should follow up on this
Yeah,
question.
definitely.
I'd love to follow up. I want to get your reframing of it, because it was just fucking perfect. Okay? Excuse me. You know, when you edit this, edit all the expletives out of it. I apologize in advance. I realize it's,